Florida beach laws have changed recently with regards to who has access, the way you get access, those kind of things. My name is Mike Renick. I'm the senior broker, the team lead with Team Renick Real Estate Services, part of that great Keller Williams on the Water family, serving the west coast of Florida. Welcome to Title Time. This is the October 17th edition with Title Time with Mike and Mike. We're going to discuss that topic in depth here in just a couple of seconds. Let me introduce Mr. Hankin, who has graciously agreed to join us every Wednesday. He's an attorney with the law firm of Hankin & Hankin. He practices primarily in the areas of residential, commercial real estate transaction. I'm looking for the right line here. He is a board certified real estate attorney, the highest level of recognition granted by the Florida Bar, and he regularly represents buyers, sellers, and lenders in all aspects of real property transactions. He is an all-around good guy, and he joins us every Wednesday morning to answer questions and keep us up to date with issues that are pertinent to us. So if I hit the right buttons here, Michael will be joining us. Good morning, Michael.
Good morning, Mike. How are you?
I'm fine. How are you?
Doing great. Thanks so much.
I'm slowly learning here in terms of I'm shortening your intro. You would like me to shorten it even more, I know, but you know, I just don't follow directions that well sometimes.
Well, no problem. One of these days I'm going to have Eric take that introductory sheet and throw it in the garbage when you're not looking.
Even though I print it out, I have soft copies and he doesn't know where they're at. Michael, welcome. It's our pleasure and honor to have you here. We've got a beautiful day here in Florida.
We do. Thank you so much for having me. Really enjoy doing this. Today we are going to be discussing the new beach law that was passed and went into effect July 1st of this year. This law has really created a lot of confusion. It's gotten a lot of media attention, and it really doesn't do a whole lot. What it's intended to do is determine whether or not the public can use privately owned beaches. So in a nutshell, we start out and we have to determine whether or not the particular beach in question is a private beach or a public beach. So first, this law doesn't affect public beaches. It doesn't affect Siesta Key Beach, Lido Beach, any of the public park beaches that you would go to. We're only talking about beaches which exist behind privately owned property. So looking at those beaches, we have to take a look and say that land behind the privately owned property, is that public land or private land? Some areas like Longboat Key, which has an established beach renourishment project, have created this really cool thing called an erosion control line, which makes that dividing line very, very simple. You look for the erosion control line, anything towards the water belongs to the public and can be used by the public. Anything landward of the erosion control line is private. Real cut and dry. That's not at all affected by the new statute. So areas like Longboat Key aren't really affected because they have this new erosion or because they have an erosion control line. Other areas that don't have an erosion control line is where this new statute really comes into play. What the legislature did is say that in the area, to back up here for a moment. First, on the areas that don't have erosion control lines, you look for where the natural dividing line would be between public and private rights. And that's where the median high water line is. So if you go out back and you see where the average high water line is, anything westward of that here or towards the water is public, and anything that's eastward or towards the land is private right. Now, historically, people have, and we call the areas westerly of the mean high water line wet sand, just for ease of use, and the areas landward of the mean high water line dry sand. So what this law really does, since we're narrowing this down, is address the rights to use dry sand on privately owned property. That's land that's landward or dry sand landward of that median high water line. So what the government did when passing this statute really is just intended to codify what the existing law already was in the state, but just to make it very clear. What they said is that local governments can't let the general public use those private portions, those areas of dry sand landward of the median high water line, unless they do a few things. The government's got to publish a notice of intent to pass an ordinance which would allow the use of that property. The government would have to file a lawsuit and then prove in that lawsuit that the use of that dry sand area has been ancient, reasonable, without interruption, and free from dispute. So essentially, as long as the public has been using that area of dry sand for an ancient amount of time, however long that is, according to our laws, that right continues. It just needs to now be bolstered or supported by a lawsuit that the government would have to file to prove its ancient, reasonable, and dispute-free use of those public lands. So it's gotten really a lot of press. It's complex, it's confusing, it deals with erosion control lines and mean high water lines, which people don't normally run into. But really, when you boil it down, it doesn't really affect us here locally that much. And across the state, all it's really intended to do is to make the way the public uses privately owned property uniform, so that there is a standardized way for the government to take and continue the use of those dry sand areas that are landward of the median high water line. Does all that make sense?
It does. Let me ask a question. I'm resisting making a comment on when we try to simplify things on how that doesn't always appear in the outcome. Maybe let me say it that way. On the islands out here, the barrier islands outside of Sarasota, meaning Siesta Key, Longboat, Anna Maria, all of those. Other than where there are official public beaches with parking spots and picnic tables and stuff like that, the rest of the beaches, for the most part, are those considered public and you can walk from one end of the island to the other unabated?
So the areas that are considered public that are behind privately owned property are only those areas that are wet sand, that are seaward of the median high water line. And this law enacts a way for the areas of dry sand to also become public. But by default, the only area that the public's allowed to walk on is those wet sand areas, the areas seaward of the median high water line. So this statute is a way for the local municipalities to enact an ordinance to allow the public to use the areas of dry sand that have been historically used by the public.
So right now, if we look out here along Longboat Key in the areas of dry sand, does that now mean it's non-public, or did this ordinance make it officially public?
So Longboat's an interesting situation. Longboat has an erosion control line. So for Longboat, we just look at the erosion control line, and wherever that particular line is where the dividing line is between public and private. Erosion control lines are pretty cool. They're these lines that usually accompany beach renourishment projects. So out on Longboat, they truck a bunch of sand to the beaches to continue to renourish the beach. Well, you can imagine the government doesn't want to come and spend millions of dollars adding sand to the beach to no longer have the rights to that sand and have the rights of the public to use that sand. Mm-hmm. So what they do when they start this beach renourishment project is they literally draw a line in the sand and they say, listen, we're going to be adding to your beach. We're going to be making your beach larger. So as we do that, so you know, we're going to be allowing the public to use the extra land that we bring in, which is only fair. The public is paying for the extra sand. The public should use the extra sand. So this new statute doesn't apply to areas like Longboat that have an erosion control line where it's very cut and dry. That line is the dividing line between public and private rights, and you don't need to look further. It only applies to areas which don't have an erosion control line, where the dividing line is somewhat murky. And in those areas, then we go through this procedure of the government filing the lawsuit and figuring out whether or not the use of the public has been ancient enough and reasonable and without dispute for long enough to have established that right.
It's clear. You did a great job. I'm chuckling because right up front you said that the motivation of the legislature was to clarify and simplify. Might I suggest that I would grade them in my old professor days as a 0 on this in terms of clarification and simplification?
It really is a complex topic. You don't run into mean high water lines and erosion control lines on a day-to-day basis. And even if you do, you probably don't know the legal effect. The good news is with the erosion control lines on areas like Longboat, it's easy. It's simple, it's cut and dry. On other areas, it's a little less cut and dry. But the good news is if you're looking at an area which does not have an erosion control line, we can look through the title history and determine whether or not there has been a court order allowing the public use of the dry sand area on the property that a particular buyer is looking at. And then at least they would know whether or not the public currently had that right, whether or not then the private property owner could exclude the public from walking across the dry sand areas of the beach. So you imagine if you're buying a waterfront property for millions of dollars, you may want to exclude people from walking up and down your backyard, and knowing whether or not that right of the public has already been established is, I think, going to be pretty important.
That's an excellent point. Absolutely. That brings it home very well, Michael. Another great job. You take complex topics and you make them so that all of us can understand. I really appreciate that.
Well, thank you. I'm always happy to be a part of it. I have a kind of a neat one, a teaser for next week.
Okay, go ahead.
And every day here at the office, I use the same 3 websites, which give me a ton of information. And I thought for next week, we could go over those 3 websites. I could tell you how I use those websites on a day-to-day basis to gather information about various properties, gather information about sellers, their liens, their encumbrances, their taxes. And these are all the tools we utilize when we're representing a buyer in evaluating the purchase offer, and what price to go in, how flexible the seller is, things about the property and so forth. So I thought that would be a great topic for next week and really provide some value and some help.
Michael, that's an outstanding topic. I love it. In fact, I can't wait. Maybe we should film this thing like in an hour and I'll just hold it for another week or something. That's going to be great information. Thank you. I'm looking forward to that.
Sounds good. And I'm looking forward to it. It should be very helpful.
Michael, if someone wants to reach out to your office, what is your phone number?
You can give us a call anytime. We're at 941, of course, 957-0080. And we love this stuff. We're always happy to talk about it. Call anytime.
Michael, you're the best of the best. Thank you for being here this week, and I will see you again next Wednesday morning.
Sounds good. Thanks, Mike.
All right, take care. Thank you.
Thanks.